Thank you for watching Divorce Nation. On this channel, we discuss marriage and divorce. Hi, my name is Ed Kadosh, and today's topic is Meet and Confer Court Rules. Before we start, I have to give to you a disclaimer. What I am about to tell you is for entertainment purpose only. I am not a lawyer and I do not offer legal advice. If you need legal advice, look for a competent and honest attorney with an active license and without disciplinary complaints against him or her. Do not take legal action based on a video you watched on the internet. Now that we have the disclaimer out of the way, I want you to understand that, at least in theory, your ex-wife or soon-to-be ex-wife cannot wake up one day in the morning and say, you know what, today I'm going to fabricate a claim against my ex-husband in order to inconvenience him and drag him to court. As a baseline, when you step inside the divorce court, your critical thinking alerts you about the improbability and exaggerations of many claims presented to the judge inside the courthouse. So how come so many incredible, unbelievable, and incorrect claims appear in front of the judge? The answer might be because the meet and confer court rules were not followed. Please watch my video called What is a Motion in order to better understand what I'll be trying to tell you today. Before sending a motion to court, most courts require you to have a discussion with your opponent about the issues in order to clarify, minimize, and even solve the problems. In other words, the court might have a rule that says that you have to discuss, consider, talk about, and exchange views about the issues before bringing the matter to court. Many courts created the meet and confer rules to motivate people to solve their issues outside of the tribunal. Unfortunately, many divorce courts are overwhelmed with the amount of motions they receive every day. Sadly, the amount of litigation in divorce courts has increased exponentially. And chances are that if you are married today, or if you are thinking about getting married, soon you will be involved in all kinds of litigation against you. Now back to the subject. Some lawyers hide from you the meet and confer rules because if issues were solved between you and your ex-wife with a simple conversation, some lawyers would lose a lucrative source of revenue. Remember that there is a conflict of interest between you and your lawyer. Also, there is a conflict of interest between your ex-wife and her lawyer. The more litigation and the more the number of motions that are sent to courts, the more both lawyers make money. On the other hand, the more you and your ex-wife discuss and solve problems, the less money both lawyers will make. Maybe now you understand why some lawyers hide from you the meet and confer rules. Soon I'm going to create a little booklet explaining to you in more detail how to use the meet and confer court rules in order to avoid unnecessary litigation and potentially save you many thousands of dollars in legal fees. Different ex-wives have different reasons for bringing their ex-husbands to court every month. Some want to bankrupt them. Some want to attempt to change parenting time. Some want more money in child support. Some want to control the time and the lives of their ex-husbands. The examples are endless. Step inside a divorce court and you will probably understand what I'm trying to tell you. Now back to the meet and confer strategy. Next time your ex-wife threatens you with court litigation and raises an issue, you tell her that you understand her concern and you ask her for a date where you both can meet and confer in order to narrow and even solve the issues. If the issues are serious and if the concerns are not fabrications created to drag you to court, she should sit down and discuss the problems with you. If the issues are inventions, she will do everything she can to avoid the meet and confer session. She would rather have the discussion taking place in front of the judge. Maybe the reason why she avoided the meet and confer session was because she realized that she didn't have any evidence or proof to support her claims. Now she has two choices. Choice number one, give up on the idea of taking frivolous claims to court. If she decides to give up, that's the end of the litigation against you. You won the case without having to step inside the courthouse. Choice number two, she decides to avoid the meet and confer session and she chooses to take her claims to court anyways. Now what? What should you do now? Your course of action will depend on a number of factors, but for the sake of our example, you should decide to use the meet and confer rules against her. Explain to her that you object her from sending a motion to court because the court rules require you to meet and confer before any kind of court action. Let's say that she refuses to follow the court's rules and she decides to send a motion to court anyways. During the hearing, you should explain to the judge at least 7 things. Number 1, that you were concerned about her issues. Number 2, that you asked her for a date for you two to meet and confer and discuss the issues. Number 3, that she refused to meet and confer and follow the court's rules. Number 4, that you object to that hearing and her motion. Number 5, politely request the judge to take notice that you object to that hearing taking place because the meet and confer rule ordered by the court was not followed. Number 6, respectfully request the judge to advise your ex-wife about the necessity of following the law and obeying the court's rules. Finally, number 7, courteously request the judge for an order where it explicitly says that before your ex-wife sends motions to court, she shall meet and confer with you according to the court's rules. If the judge provides you with your requested order, this order alone could potentially save you many thousands of dollars in legal fees. In a perfect world, the judge should do exactly as you requested. But there is a small number of reasons why the judge would not respect the rules. Believe it or not, depending on the rule, the law, or the situation, the judge might have the option of not following the rules. I'm going to talk more about this subject in my next video called Judge's Discretion. Just in case the judge decides not to follow the rules, have your answers ready and explain your side of the story in front of the judge. This video is an oversimplification of the meet and confer rules. During this video, I have not answered several important questions, like, for example, in response to your ex-wife's motion, should you send a response motion or a motion to dismiss? What if your ex-wife claims that her issues were urgent and she didn't have time to meet and confer? What if lawyers are involved? How to request her lawyer to follow the meet and confer rules? What if you have a lawyer that doesn't want to follow the meet and confer rules either? What to do when the judge refuses to honor the meet and confer rules? Please read my booklet in order to better understand the meet and confer rules and how you can use it to defend yourself in court. I'll post the link for my booklet in the description soon. Remember to always discuss legal strategies with your lawyer. Don't forget to like and subscribe. Please leave a comment, especially if you were a victim of the divorce industry. This way we can learn from each other's mistakes. Most importantly, share this video with your friends. Above all, those who are thinking about getting married, or the ones who are going through a divorce right now. Unfortunately, nowadays, divorce is war. Avoid divorce and avoid war by not getting married. Thank you for watching.